Welcome to This Explainer. Today, we're taking a strictly evidence-led, objective look at a massive regulatory event in the tech space. We are breaking down the UK Competition and Markets Authority's active investigation into Microsoft 365 subscription auto-renewals. Now, right up front, it's absolutely crucial to establish that this is an ongoing probe officially launched in July 2026. To date, 0 findings of infringement have been made against Microsoft in the UK. We're here purely to analyze the confirmed facts, the legal framework, and the public evidence surrounding how Microsoft introduced its Copilot AI tool into consumer subscriptions. So let's ground our analysis in objective financial reality. Back in January 2025, Microsoft updated its UK consumer plans to reflect the integration of its generative AI assistant, Copilot. The new Copilot integrated plans list Microsoft 365 Personal at $84.99 per year and the Family plan at $104.99 per year. Alongside those, Microsoft offered a non-AI Classic plan, which essentially preserved the historical feature set without Copilot. When you look at these tiers side by side, the core mechanism of this whole investigation becomes crystal clear. It's all about the transition between these exact price points. And that brings us to this specific number, £25. This is the annual price difference for both personal and family plan subscribers between the new Copilot plan and the Classic alternative. This £25 differential is the absolute nucleus of the CMA's transparency investigation. See, the regulatory question isn't whether Microsoft is allowed to charge money for AI. The question is whether the communications regarding this £25 difference were sufficiently clear before existing customers auto-renewed. To break this down logically, here is our roadmap for today. We'll examine the £25 renewal choice, what the CMA is actively investigating, and the legal frameworks at play. Then we'll separate the confirmed UK facts from global allegations, look at 2 competing interpretations of the situation, and finally, map out the possible paths forward. Let's jump right into Section 1, the £25 renewal choice, to establish the baseline reality of this product update. Here are the mechanics of how this rollout actually worked in the UK. In January 2025, Microsoft gave existing Microsoft 365 personal and family subscribers access to Copilot at no extra cost for the rest of their current billing cycles. The catch? When that cycle expired, auto-renewing customers were automatically defaulted onto the new, higher-priced tier that permanently included Copilot, unless they actively intervened. To accommodate folks who didn't want the AI tools, Microsoft offered a Classic plan. So mechanically speaking, taking no action resulted in a £25 price increase, while maintaining the legacy price required you to actively select it. Which leads us to Section 2, what the CMA is investigating. Let's look at the exact regulatory scope of the July 2026 probe. The central analytical question the CMA is asking is this: did existing UK customers receive sufficiently clear, timely, and actionable information before those auto-renewals processed? The regulator has stated there are concerns that Microsoft's pre-renewal communications might have been misleading. They're specifically zeroing in on the prominence of the downgrade option. In today's subscription economy, choice architecture matters immensely, and the CMA wants to know if that £25 structural price difference was made completely unambiguous to consumers who naturally rely on default auto-renewal settings. In response to all this, Microsoft has maintained a highly cooperative stance. A company spokesperson officially stated that they're reviewing the CMA's claims in detail and are committed to working constructively with the regulator. It is paramount to remember that this investigation is strictly in an initial evidence-gathering stage, and Microsoft has not been found guilty of breaching any UK consumer protection laws. Moving on to Section 3, the enforcement legal framework. To understand the gravity of this probe, we have to look at the dual legal frameworks in play. Currently, the CMA is operating under Part 8 of the Enterprise Act 2002. Simply put, this is purely the evidence-gathering phase. It gives the regulator the authority to request internal documents, review communications, and analyze the user interfaces Microsoft deployed. Functioning under Part 8 confirms this is strictly an exploratory stage to determine if there's even a case to answer. However, if evidence of a breach actually is found, the CMA now wields newly activated powers under Part 3 of the Digital Markets Competition and Consumers Act, or the DMCA. These powers, which just went live in April 2025, are a real game-changer. They allow the CMA to determine consumer law breaches administratively and issue direct compliance directions without having to go through the courts first. So this case is effectively a massive, bounded test of these new direct enforcement capabilities. Now, what's really notable here is this figure: 10%. Under the DMCC Act, the CMA literally has the statutory authority to levy financial penalties of up to 10% of a company's global turnover. But I need to heavily caveat this right now. That 10% is strictly a statutory maximum penalty for verified consumer law breaches. It is absolutely not a guaranteed outcome, it's not a forecast, and it is definitely not an expected fine for this specific unresolved case. It merely illustrates the maximum regulatory exposure under this new legal framework. Let's transition to Section 4, Global Allegations and Unknowns. It's incredibly important we separate the confirmed UK facts from parallel international developments so we avoid any false equivalence. Internationally, Microsoft is facing very similar scrutiny, most notably over in Australia. The Australian Competition and Consumer Commission, the ACC, initiated federal court proceedings alleging Microsoft actively concealed the cheaper Classic plan behind a cancellation flow. But here is a highly crucial unknown for us. We do not know if the UK user interface functioned identically to the Australian one. The CMA is investigating the UK communications, but there is absolutely no public evidence confirming that the mechanisms alleged in Australia were actually deployed to UK consumers.
This comparative model illustrates the core concept at play, but strictly as comparative context. On the left, you see a transparent choice architecture, where renewal options are presented side by side. On the right is a conceptual model of a cancellation-gated flow, which is what regulators allege happened in Australia. In that model, a user basically has to initiate the process of canceling their entire subscription before a screen pops up revealing the cheaper legacy plan. Whether this structural friction actually existed in the UK is precisely the evidence the CMA is currently gathering.
This table neatly summarizes the global landscape for us. We've got the UK CMA conducting an open investigation into transparency. We have the Australian ACCC making formal allegations in federal court about cancelling gated flows. And Italy's AGCM is conducting their own open investigation into potentially fragmented pricing information. So while regulatory scrutiny is obviously a widespread pattern here, we must remember that no legal liability has been established in the UK.
Which brings us to Section 5, two competing interpretations. Given those unknown facts, there are two distinct, balanced ways to look at Microsoft's update. On one side, we have the regulatory and consumer protection view. This side argues that because we all rely so heavily on auto-renewal defaults, any structural price increase absolutely requires unambiguous transparency. If a cheaper alternative isn't featured prominently, it hinders informed consent and looks like an unfair commercial practice. But conversely, we have the industry and commercial enhancement view. From this perspective, the Copilot integration is completely standard product evolution for software as a service. Features get updated, prices adjust, and the Classic plan was simply offered as a transitional option for legacy users. Regulating interface design too strictly, under this view, risks stalling software innovation entirely. Finally, let's dive into Section 6, possible paths and next steps, and outline the bounded future of this action. Mapping out the chronological journey, we see the product change in early 2025, the CMA gaining its new powers shortly after, and the formal launch of this probe in July 2026. The next critical date to watch is the end of December 2026. The CMA has indicated they expect to provide a procedural update by this time, which could finally clarify the direction of their findings.
Based on the framework, there are three possible resolutions we can logically anticipate. First, case closure. The CMA concludes that the communications were actually sufficiently clear under UK law and just drops the probe. Second, negotiated undertakings. This is where Microsoft preemptively offers binding commitments to revise its subscription dashboards, leading to closure without an infringement finding. Or third, formal enforcement action. The CMA determines a breach occurred and uses its DMCC powers to mandate changes or levy fines. Crucially, if a final enforcement notice is issued, Microsoft retains the statutory right to appeal that decision to the High Court within 60 days. Now, we obviously cannot forecast which of these scenarios will occur. And that leaves us with this final, unresolved analytical question. Did Microsoft provide existing UK customers with sufficiently clear, timely, and actionable information about that £25 difference before auto-renewal kicked in? We know the CMA is investigating. We know the £25 difference is real, but the internal metrics and the ultimate regulatory conclusion remain entirely unknown. Ultimately, the CMA's December update won't just decide this specific case. It's going to signal exactly where regulators intend to draw the line for consumer consent in this new AI economy. Thanks for joining us for this explainer, and we'll catch you next time.